Comicsgate trademark trial suspended while the Trademark Trial and Appeal Board listens to Ethan Van Sciver's motion to dismiss. Hello, this is Robert Romano with Comicsgate.org. Hit that subscribe button. Today we're going to be talking about the Comicsgate trademark trial. It has just been suspended following a motion to dismiss by Ethan Van Sciver and his attorney Scott Houtteman. And I think that this is getting really interesting right now. According to Young O. Richard Kim, interlocutory attorney, quote, as last reset, this is on August 6th, quote, respondents were allowed until August 2nd, 2021 to answer the petition for cancellation on August 2, 2021. In lieu of an answer, respondents moved to dismiss the petition for cancellation. When a party timely files a potentially dispositive motion, the proceeding is suspended with respect to all matters not germane to the motion, and no party should file any paper not germane thereto except as otherwise may be specified in a board order. Accordingly, as of the filing date of the motion to dismiss, proceedings are suspended pending further disposition of the motion. Any paper filed during the pendency of this motion, which is not germane thereto, will be given no consideration. The motion to dismiss will be decided in due course, and it states in the footnote the schedule for the discovery conference, initial disclosures, and discovery will be reset in the event proceedings are resumed. Trademark Trial and Appeal Board Manual of Procedure. So this is normal course of business when you have a motion to dismiss. According to the Trademark Trial and Appeal Board rules, you can have a suspension of the proceedings, and this is the potentially dispositive motion when a party to a board files timely a motion potentially dispositive, such a motion to dismiss, a motion for judgment on the pleadings, or a motion for summary judgment. The case is considered automatically suspended by operation with respect to all matters not germane to the motion. So what this means is that no other motions are going to be considered right now. And the only thing that can happen is Preston Poulter, Pocket Jacks Comics, would have to respond to this motion to dismiss. They could respond or not respond, but they're going to be considering this motion to dismiss that was filed by Ethan and his attorney, which I find really interesting. Ethan Van Sciver strikes back, files motion to dismiss Preston Poulter's attempt to steal Comicsgate. And so, as I mentioned, on August 2nd, Ethan filed a motion to dismiss a complaint by Preston Poulter to cancel the federally registered trademark that was originally initiated by Antonio Malpica, but now Ethan Van Sciver owns it. So Antonio, he applied for this back in 2018 after Comicsgate had started coalescing around Ethan. In the summer and spring of 2018, Antonio goes ahead in September of 2018, makes the application, and eventually it gets all the way through the registration process in 2020 in July. And now Antonio has assigned the Comicsgate trademark that he applied for, assignment of the interest and goodwill of the mark, to Ethan. And so Ethan owns Comicsgate trademark right now for the purposes of making comics. But as the motion to dismiss outlines, Ethan has a common law trademark which supersedes the original application by Critias Antonio Malpica. Co-defendant Ethan Van Sciver, through counsel, moves the motion to dismiss this proceeding. Petitioner Comic Sense Press Incorporated, doing business as Pocket Jacks Comics, lacks a statutory cause of action to challenge the trademark registration, which divests the Trademark Trial and Appeal Board of jurisdiction. Petitioner Common Sense Press has based his entitlement to bring this cancellation proceeding on the fact that petitioner's own trademark applications were suspended in view of defendant's registered trademark. Ordinarily, this is standard, uncontroversial grounds to seek cancellation of that registration. But this is no ordinary case. Here, as defendant will show, petitioner's applications are void ab initio from the beginning. Petitioner filed 2 applications declaring its intent to use the mark Comicsgate, but petitioner was not the proper party with a bona fide intent to use the mark. The public record, largely a selection of petitioner's own admissions, shows Comicsgate in commercial use years before petitioner filed its own application. That's Preston Poulter. So Preston Poulter applies for this mark in April of 2020. He goes for a certification mark in May of 2020. but according to Preston Poulter's own tweets and videos and commentaries, not only is he not a part of Comicsgate has been in business since 2018. Thus, quote, petition is a mere intermeddler, a self-appointed guardian of the trademark register, and has no statutory right to bring this cause of action. So here, Ethan and the attorney are attacking Preston Poulter's standing to bring a complaint against the Comicsgate trademark because they're arguing Preston's applications were never really legally grounded, because Preston knew that Comicsgate was already in business, that Ethan was utilizing the trademark and had been doing so for years. And Preston's been criticizing Comicsgate and blasting Comicsgate and basically calling it a scam, even as it was raising millions of dollars, which he is well aware of. So I think that this is an interesting motion to dismiss. Having standing is really easy. It's a rifle shot, but it's also a long shot, because it's really easy for Preston to show that he does have standing because he has his applications in for the trademark. So normally, if you have an application in for a trademark, that is more than enough grounds to bring a proceeding. But what the motion to dismiss is doing is asking TTAB, the Trial, Trademark, and Appeal Board, to consider Preston's applications right now and to look at the fact that they were never legally filed, because he is well aware of the fact that Comicsgate was in business for years and years. And so let's go over portions of this, and we'll go back to my piece here. On July 26th, the U.S. Patent and Trademark Office resumed proceedings of the trial, with Van Sciver being named co-defendant in Poulter's attempt to wrest the Comicsgate trademark away from Malpica, as Poulter's motion for judgment on the pleadings was denied. And I think that's incredibly significant insofar as they could have awarded summary judgment to Preston Poulter and immediately canceled Antonio Malpica's old trademark. Instead, they said, let's set a trial. This motion for judgment on pleadings is denied as, quote, the motion is based on a submission that the board does not construe as a proper pleading. Malpica's submission of November 9, 2020 is less a cognizable answer to the petition than it is merely argument more appropriate to a brief in the case. The filing is therefore unacceptable as a responsive pleading upon which a motion for judgment on the pleadings may lie. So Antonio never properly defended the mark in front of the TTAB, the Trial, Trademark, and Appeal Board, and so they denied for a motion of judgment on pleadings to Poulter. And so that was round one. It went to Ethan. They allowed Ethan to come on to the trial as a co-defendant, and now they're filing motions to dismiss on the basis that Preston actually lacks standing to bring such a complaint. And so this is all very interesting. Now, with his latest filing, Van Sciver and Houtteman go on the offensive, seeking to end Poulter's bid with one swift stroke. Here, Houtteman argues that Poulter lacks standing. We covered that part. A note to readers is that demonstrating standing is a preliminary part of the trial. Poulter has to show he is aggrieved by Van Sciver's ownership of the Comicsgate federal and common law trademarks. Here, Houtteman notes that normally Poulter's applications at the USPTO would be enough to constitute standing, but that given the facts, this is no normal case. And one area of attack that Ethan and Scott Houtteman are using is to argue that when Poulter filed in April and May of 2020, he did so on basis of intent to use as opposed to actively using it, and they had to swear to TPO that nobody else was already using it. Quote, that no other persons have the right to use the mark in commerce, either in the identical form or in such near resemblance as to be likely when used in connection or in goods and services of such other persons to cause confusion or mistake or to deceive. But based on Poulter's own admissions, he knew that to be false. He swore to the USPTO that nobody was using Comicsgate to his knowledge. And to his knowledge, a lot of people were using Comicsgate. And we're going to go through some of these tweets here. This was on July 9, 2019, where Preston Poulter writes on Twitter, quote, group labels serve to solidify the nebulous and varied goals that make up a group's affiliation. In this case, Comicsgate is a label which EVS has defined the meaning of the group, as well as defended it against use by unwanted outsiders. His fans make up the vast Comicsgate majority. So that sounds a lot like a trademark. And certainly it shows knowledge on Poulter's part that Comicsgate is in existence, that Ethan Van Sciver has defined the meaning of the group and has defended and protected Comicsgate from unwanted outsiders. So that's called defending the trademark. And so to even to Preston Poulter, he's a self-appointed expert on trademark law when he went ahead with this BS proceeding, in my view. That would sound like a trademark. And he would later complain that he was never allowed to appear on Ethan's YouTube channel to promote his project. And Poulter has since attempted to focus on canceling the mark that was once owned by Antonio Malpica, but has been assigned to Ethan since April for use in comic books. And Preston knew that it was profitable on January 9, 2019, more than a year before filing an application for the mark. Poulter, in a YouTube video, admitted that, quote, the biggest numbers put up on the scoreboard for indie comics are, quote, dedicated Comicsgate people such as, Ethan Van Sciver. And so here's a clip of Preston talking about that.
When it comes to the Comicsgate crowd, Ethan Van Sciver and Richard C. Meyer kind of define the genre. They are essentially the ones defining Comicsgate and saying what it is. And if this is their work, then how could we possibly criticize the work of what is defining the genre? I mean, all other works would basically need to be compared to those two, right? But the thing that's different about Comicsgate is it's not only this kind of movement against the establishment, but it also is now becoming somewhat of an artistic brand, although it's very loosely defined artistic brand. Right now it feels much more just like have the appropriate people smiled upon you and the non-appropriate people cursed you, in which case here's your Comicsgate badge. So anyway, and that's not art, that's just pure group affiliations, and who wants to get caught up in all that?
And so there you have it. It's a group affiliation. And here he goes on to say, quote, as a small comic creator, you're going to naturally kind of find yourself either falling in with or having to actively reject the Comicsgate crowd, because if you're looking at it, the biggest numbers put up on the scoreboard for indie comics, they're going to be dedicated Comicsgate people such as, Ethan Van Sciver and Richard C. Meyer. And, he's put up some impressive numbers up there, not only for himself, but also Antonio Bryce with Brand. Talking about Ethan, he was able to take a guy who had just an idea for a comic and, just some preliminary artwork and get him to now 55,000 on the crowdfunding website Indiegogo. And so, there's certainly that temptation to go, quote, okay, I'm all on board with Comicsgate, and on it goes. I mean, here Preston was clearly admitting that Comicsgate was a movement that maybe he wanted to join but wasn't allowed to, and so he was kind of gate kept out of it. Really all that happened was Ethan didn't have him on his show, and so then he starts this offensive, this years-long feud with Comicsgate and Comicsgate creators and Comicsgate leaders like Ethan Van Sciver, and now trying to destroy Comicsgate, which he actively admits. Again, he repeats the admissions of Van Sciver's ownership of the Comicsgate trademark for use in commerce, and I think it's pretty amusing. It's the bulk of exhibits provided and Ethan's motion to dismiss. And at one point on November 19, 2019, Poulter promised to destroy Comicsgate. Look at this. Only to you, seriously, you alpha males need to report to a safe space to be shielded from respectively presented opposing views. Also, I am working for the destruction of Comicsgate and would never willingly hire anyone associated. So put your outrage where it belongs. So here, this seems to be at odds with owning a trademark at all, which is if you're trying to destroy a brand, you can't own it as a trademark. That's the opposite. And so Van Sciver via Houtteman argues that neither Malpica nor Poulter's applications, so from September 2018 or Poulter in April 2020, applications were ever legitimate because Van Sciver was using Comicsgate as a service mark since July of 2018 on his YouTube show Comicsgate Live and has never stopped using it. And as far as the destruction of Comicsgate, quote, Poulter's use of Comicsgate is not limited to the destruction of a comic book trademark, but includes destruction of the service mark. So when Poulter is talking about Comicsgate, he's not merely referring to something you would put onto a comic book. He's talking about this widespread movement, which includes all these YouTube channels. And so returning to Ethan's motion to dismiss, which is the relevant portion of this, in order to invoke the board's jurisdiction, petitioner has a burden of establishing statutory cause of action. Here we're going to go to standing again. In order to maintain a petition to cancel a registered trademark, the petitioner must prove its entitlement to a statutory cause of action. The real interest test is to distinguish parties demonstrating a real interest from mere intermeddlers or meddlesome parties acting as self-appointed guardians of the purity of the register. In deciding a motion to dismiss, the board is not limited to the four corners of the complaint, but may also consider matters incorporated by reference or integral to the claim itself, subject to judicial notice, and matters of public record. Also, the board may take judicial notice of adjudicated facts not subject to reasonable dispute because they can accurately and readily be determined from sources whose accuracy cannot be reasonably be questioned. So like YouTube or Twitter, where Poulter is talking clearly. Finally, in matters involving the board's jurisdiction, a motion to dismiss may be treated as a motion for summary judgment, provided the parties are given an opportunity to present evidence and argument on that question. Now, here we go. Common sense presses applications and the public record integral to its claims show Poulter to be an intermeddler. Poulter claims a bona fide intent to use Comicsgate. In its complaint, CSP asserts a single grounds to establish its statutory cause of action being to bring this cancellation proceeding, the harm from the USPTO suspending his two applications. The complaint addresses only this registered trademark from Antonio Malpica, but there is another Comicsgate trademark, a common law service mark, generating millions of dollars in revenue. The CSP complaint completely ignores the service mark. Intent to use applications are void ab initio when filed by a party who is not entitled to use the mark in commerce. Now, his applications, because he said, oh, I didn't know anyone else was using this, Ethan and Scott Houtteman are arguing that makes them void. These applications are not a basis to bring a cancellation proceeding because they were never valid to begin with. An application under the basis of intent to use on the Lanham Act, Section 44, must be filed by a party entitled to use the mark in commerce as of the application filing date. The application is void ab initio when the person designated as the applicant is not the entity with the bona fide intent to use the mark. The public record shows Comicsgate is an existing mark owned by another with prior and superior rights to Preston Poulter. Now, as the board knows, trademark rights are acquired by use in the marketplace. Quote, the most fundamental aspect of U.S. trademark law is that trademark ownership and attendant rights are acquired in the marketplace by use. Indeed, the Lanham Act explicitly protects unregistered marks from both infringement and trademark dilution. Defendant's Comicsgate service mark was in use since 2018. Here we go. Defendant Ethan Van Sciver will now present portions of the public record integral to Poulter's complaint. It shows starting in the spring of 2018 and continuing to the present time, Mr. Van Sciver has used Comicsgate in commerce. This is well before the filing date of Poulter's applications. Mr. Van Sciver is a 20-year veteran artist who has worked for Marvel and DC Comics. I think it's 28 year. Books such as Green Lantern, Flash, Superman, Batman, and X-Men. He is now one of a number of independent comic book creators. And he's raised millions of dollars with his Cyberfrog and All Caps Comics brand of comics under the Comicsgate banner and movement and brand. He began using Comicsgate in commerce in the spring of 2018. For example, he promoted the crowdfunding of independent comics under Comicsgate. He used it to raise $1.2 million with other creators, at least 5 from the get-go. This exhibit, we can look at the exhibits in a little while, includes specimens currently under file, including Mr. Van Sciver's application. Now, Poulter admits Comicsgate was used in commerce to promote the sales of comic books prior to Preston Poulter's application filing dates. CSP's statements are in the public record and qualify as admissions by a party opponent. Common Sense Press is a Texas corporation owned by Preston Poulter. Mr. Poulter also owns his YouTube channel entitled Pocket Jacks Comics. This channel, like many YouTube channels, saves audio-visual records that can be viewed by anyone at any time via the internet and as is indicated by various links. The relevant excerpts in context have been transcribed and are made for record here. The statements presented are all of those of Mr. Poulter. Mr. Poulter, as the owner of Common Sense Press, is a party to this proceeding. Accordingly, his statements are all admissions by a party opponent and can be used for any purpose. So Preston Poulter had all these tweets and videos about Comicsgate in the years leading up to his application, where he admits he's not a part of Comicsgate, that Ethan Van Sciver owns and operates the Comicsgate brand via his YouTube channel, that he gatekeeps people off of his YouTube channel, like Preston Poulter, and he's jealous, and so he wants to be on that channel too, and he wants to sell his brand. On January 7, again, well before Poulter filed his trademark application, Poulter admitted when it comes to the Comicsgate crowd, Ethan Van Sciver and Richard C. Meyer defined the genre, and we covered that part. Note the preceding admissions by Poulter make up the core of defendant's motion to dismiss. Poulter's admissions, all by themselves, evidence the very definition of a Comicsgate service mark actively in use in commerce. How can Poulter, in good faith, later apply for the Comicsgate trademark, claiming that no one else has the right to use Comicsgate in commerce? Continuing on with the public record showing, as Poulter pointed out, Mr. Van Sciver invites guests onto his YouTube channel and in association with the mark Comicsgate, helps them raise funds on the crowdfunding site Indiegogo. Attached to this brief is the public record of the Comicsgate campaign mentioned by Mr. Poulter. It's a campaign to fund Antonio Bryce's 2018 brand comic, which ultimately raised $78,000. So, brand by Antonio Bryce and Kane and White was on Indiegogo. They got onto Ethan's channel in 2018, and Ethan helped them raise tens of thousands of dollars for the Comicsgate book by just virtue of being on the Comicsgate Live program that Ethan was hosting. In addition to promoting Mr. Bryce, Mr. Van Sciver promoted 7 other independent comic creators: Asami, Galactic Comics, Brutus the Badass, Black and White by Art T. Bear, Lone Star by Mike Miller, Bigfoot Bill by Doug Tenable, and Graveyard Shift by Mark Poulton and John Malin. Importantly, Poulter admits his is not associated with Comicsgate in any way. In fact, he once requested to appear on Mr. Van Sciver's Comicsgate channel and did so insistently. Unfortunately, that led to Mr. Van Sciver calling Mr. Poulter a stalker. And so Poulter complains in a video, kind of labeled me stalkery when I was asking to be on his show. Mr. Van Sciver's successful use of Comicsgate in promoting independent comic book creators soon gained recognition in the comic book industry. At the end of 2018, for example, a popular trade publication, Bleeding Cool, placed Mr. Van Sciver in its top 100 power list. Quote, Ethan Van Sciver used Comicsgate to raise over $500,000 on Indiegogo. Defendant includes additional admissions by Mr. Poulter on this trade publication thing. This goes to the goodwill argument that Ethan has the goodwill of the public when it comes to operating the Comicsgate service mark. When people think of Comicsgate, they think of Ethan Van Sciver, and you need only look at this trade publication, Bleeding Cool, having stated that Ethan Van Sciver uses Comicsgate to raise millions of dollars on Indiegogo. I mean, that is affirmation of all the pleadings that are being made in this motion. It is definitely evidence that the board must consider. And here's the additional admissions from Mr. Poulter, a selection of his tweets. And these are devastating. Quote, Comicsgate is a label which EVS has defined the meaning of the group as well as defending it against use by unwanted outsiders. We covered that one. Here's others. EVS and friends will decide what the next iteration of Comicsgate is. Comicsgate have attacked creators who do not fulfill their identity requirements as fully Comicsgate. Comicsgate is Ethan's little club. Indiegogo allows Comicsgate creators of Ethan Van Sciver's choosing to run a second campaign. And finally, quote, I am working for the destruction of Comicsgate and will never willingly hire anyone associated. So, I mean, that's pretty well recognition by Preston that Comicsgate is a thing he's not a part of and Ethan owns. Moving on. Finally, defendant notes the continuing public recognition of the Comicsgate mark for promoting the work of independent comic book creators. For example, a Comicsgate fan has created a website, creatorgo.com/CG, that displays Indiegogo campaigns which the fan has associated with Comicsgate. When last checked, the website reported Comicsgate crowdfunding figures in 2020 and 2021 at $8.8 million. And I think it's even greater now. Go.com/CG. We'll check what the latest number is. I think it's 9.4 million. So when the TTAB, when the Trademark Trial and Appeal Boards goes to this link, they're going to see, wow, it's even bigger now. And if you look at the top campaigns here, they're all Ethans. Ethan Van Sciver, Cyberfrog 2, Wreck Planet, $1.2 million. First Wave Cyberfrog action figures, $468,000. Ethan Van Sciver's Rainbow to Brute, $445,000. Ethan Van Sciver's Cyberfrog, warts and all, $431,000. And then you start to get into other campaigns. Richard C. Myers got Expendables Go to Hell, $283,000. Blade Devil, which crowdfunded under Comicsgate, $279,000. Cecil Has Cash Grab, $274,000. Graveyard Shift Volume 3, $265,000. Cyberfrog Unforgettable Tales 1 and 2, $225,000. Richard C. Meyer, Jawbreakers, Grand Bazaar, $213,000. Fragaboom, Stan Frega's Black Flag, Pineapple Perception Comics, which was crowdfunded under Comicsgate, $209,000. That Umbrella Guy, another case for the Littlest Umbrella, $158,000. Shane Davis's Starlight Cats, Merlon Rising, $127,000. Godlike by John Malin, The Romulus Saga, $125,000. Graveyard Shift number 3 by Poulton and Malin, $120,000. And on it goes. This is a very lucrative mark, the Comicsgate mark, for the creators, particularly those that Ethan happens to be promoting on his YouTube channel. So this is definitely more evidence to be considered by the board in dismissing this case, which maybe is a good likelihood, maybe not. We'll see. I mean, again, it's really easy for Poulter to show standing in this cancellation proceeding because he has the applications. The question is, what in this motion, they'll have to consider whether the applications were void ab initio, as Ethan and Scott Houtteman are arguing. Thus, petitioner's own admissions, as further substantiated by the public record, show that another party, not Preston Poulter, has prior and superior trademark rights to the mark Comicsgate. With its applications now void, Poulter has no real interest or reasonable belief of damage. As stated above, Poulter must pass a two-part test to establish its statutory cause of action, a real interest in the cancellation proceeding, and a reasonable belief of damage as required under 15 U.S.C. 1064. Poulter loses on both prongs because Mr. Poulter, and thus petitioner Common Sense Press, knows of defendant Ethan Van Sciver's prior and superior rights to the Comicsgate mark. Poulter's intent to use applications are void ab initio. Without a valid application, Poulter has no real interest in the cancellation proceeding, and CSP has no reasonable belief of damage. Its desired use of the name Comicsgate is nothing more than brazen trademark piracy. CSP is not damaged as required under the law by this board, preventing CSP's piracy. Thus, CSP cannot establish a statutory right to this cause of action. He's a mere intermeddler, a self-appointed guardian of the trademark register, and a zone of analysis. This is my favorite part, is an alternative analytical framework. Its purpose is to, quote, foreclose suit only when a plaintiff's interests are so marginally related to or inconsistent with the purposes implicit in that statute that it cannot reasonably be assumed that Congress authorized the plaintiff to sue. The Federal Circuit has said this analysis shares a similar purpose and application as the real interest requirement. And as far as Preston Poulter's admitted goal, quote, the destruction of Comicsgate, the hashtag Comicsgate, is outside of the zone of interest, and this analysis leads to the same conclusion. So when you say you're trying to destroy the mark for which you are applying, you are outside the zone of interest. You don't have a legal claim to it. That is suspending, that is foregoing, that is dismissing your own ownership of it by saying you want to destroy that thing. So you can't own it and destroy it at the same time. Defendant notes that CSP's knowledge of Comicsgate being already used in the marketplace in connection with comics should have stopped Poulter from filing his intent to use application. As pointed out previously, both applications require sworn declarations that, quote, no other persons have the right to use the mark in commerce. Perhaps Poulter was grossly negligent in signing his false declaration. Perhaps it was a deliberate false statement. All that matters now is the fact that Poulter is not a party entitled to use the Comicsgate in commerce. Accordingly, Poulter's, both of them, his intent to use applications are void ab initio. And now response to potential arguments of petitioner. This is things that Poulter might raise in responding to this motion to dismiss. And then cases cite the suspension of petitioner's application. providing a statutory cause of action, but they're in a opposite because the issue of application validity was never raised. So this is raising other potential problems with the motion to dismiss, but saying that they don't matter because the issue of application validity in prior motions to dismiss on someone bringing a cancellation proceeding hadn't considered the application validity itself. And they're saying here, as stated previously, these cases stand for an obvious proposition. When a registered trademark causes the suspension of a petitioner's application, the petitioner has an interest in that registration and thus a right to seek cancellation of that registration. But these cases are no help to Poulter. In none of those cases was a petitioner's application challenged as void. Also, no case entitles a petitioner to an unrebuttable presumption of a statutory cause of action. Indeed, petitioner has an ongoing burden of proof to establish its right to statutory cause of action. The defendant rebuts petitioner's prima facie showing, as here, petitioner must either provide additional evidence or lose. And again, jurisdictional discovery matters. Defendant prefers this matter to be decided right now. Defendant will cooperate even if it isn't decided right now with the board should it decide the matter is best addressed on summary judgment. On jurisdictional matters, when the board decides to convert a motion to dismiss to a motion to summary judgment, the board has allowed the conversion so long as the parties are given reasonable opportunity to present all material pertinent to the motion. But defendant maintains that this is unnecessary. Poulter's own admissions decide this case. Surely Poulter does not need a chance to cross-examine himself. Finally, Comicsgate use of a service mark for promoting comics is confusingly similar to as a trademark for comics. Note that defendant uses Comicsgate primarily as a service mark, that's Ethan Van Sciver, using in promoting sales of independent comic book. Poulter's applications, on the other hand, use Comicsgate as a trademark for comic books. This is a distinction without a difference. The earlier service mark, promoting comics, precludes the use of the latter trademark for comics because the two uses are confusingly similar and cannot coexist in the market under different ownership. This is true as a matter of common sense, as admitted to by Poulter in his threat, "I am working for the destruction of Comicsgate," which is not limited to the destruction of comics book trademark, but includes the destruction of the service mark. And so the board, they have the power to decide this. Defendant now addresses potential arguments. CSP may argue the board's jurisdiction is limited to establishing the validity of registered trademarks and does not include such issues as common law trademark or whether petitioner's trademark applications are valid. But the board has the authority to consider a wide variety of issues, quote, if necessary to decide the issues properly before it. In a cancellation proceeding that was from Selva and Sons Incorporated, the Nina Footwear Incorporated, where the board may pass on validity of a copyright, for example, if it is necessary to do so in the exercise of its statutory jurisdiction. In addition to copyright validity, the board has considered issues such as the consideration and validity of agreements and unfair competition claims. The board has the authority to address common law mark to the extent necessary to decide an issue properly before the board, petitioner's right to a statutory cause of action. So if you need to look at the common law trademark and of Ethan in order to determine if Preston Poulter has a valid statutory cause of action, then they're allowed to do that. So Poulter cannot complain that his own applications are not properly before the board, that we must wait until before addressing their validity, for example, in a future opposition proceeding. So Poulter could argue, hey, you have to wait, Ethan. You can't challenge my trademark application right now because we're going to get to that later. Right now, we're challenging Antonio Malpica's application and registration of Comicsgate. So Poulter's going to want to argue about what Antonio was doing. That's what the complaint originally generated from, was when Antonio Malpica still owned the trademark, but he don't own it anymore. It's been assigned to Ethan, and so now we have to argue about what is Ethan using Comicsgate for? How long has he been using it for? Oh, he was using it even longer than Antonio Malpica. And so, very cleverly, in my view, Scott Houtteman hasn't even mentioned Antonio Malpica as a worthy owner of the Comicsgate service mark. Ethan is the owner, and certainly he owns it, the one that Antonio Malpica applied for and had registered, but he has the older, longer used service mark, the common law trademark. That is the basis for Ethan's claim to Comicsgate. When Poulter introduced the applications in his complaint, that is his applications as established in a statutory cause of action. It opened a door for challenging those applications. Moreover, rather than resisting, Poulter should encourage a full review of the issue of his applications. That way, Poulter can claim res judicata should this issue arise as its application goes forward to the registration process. Poulter is not prejudiced by having an issue decided sooner rather than later. In sharp contrast, both the board and the registrants could be inconvenienced should the board postpone the issue of Poulter's statutory right to bring this action. If the board were later found to lack jurisdiction, then all subsequent findings by the board in this cancellation proceeding will have to be vacated. The efforts taken by all parties will have been a complete waste of time. And so we've gone over the rest of this, and we'll get to the conclusion here. In view of the above, we move to find that Poulter's applications filed April 15, 2020, and May 20, 2020 are void ab initio because Poulter is not the proper party with the intent to use the mark Comicsgate. They also move to therefore dismiss this cancellation proceeding because without its Comicsgate applications, petitioner CSP has no statutory cause of action. And 3, to take any other action the board finds just and proper. Respectfully submitted, Scott Houtteman, Houtteman Law, LLC. And then there's a bunch of exhibits here that are quite amusing. I wanted to show you what Preston was saying about Comicsgate through this whole time, because I think it's pretty well devastating to his case. Here's the tweet we looked at on July 7th, where he says, Comicsgate is a label which Ethan has defined the meaning of the group as well as defended it against use by unwanted outsiders, and his fans make up the vast majority of Comicsgate. Comicsgate has come to mean EVS and his friends. EVS and his friends will decide what the next iteration of Comicsgate is. I'm working for the destruction of Comicsgate and will never willingly hire anyone associated. And so, again, these are all devastating admissions, I think, by Preston Poulter, and can very well cause him to lose this motion to dismiss. In addition to that, Ethan appeared on the Ricada Law channel, and Ricada was praising this motion to dismiss. This is actually a beautiful argument. I can't overstate this. This is a well-done motion because it addresses a lot of things, and you can listen to it here.
So this is a beautiful, this is actually a beautiful argument. Let me break it down legally what's going on in these. I've skipped over a lot of the argument. Again, this is a well-done motion. I can't overstate that. I can't overstate that. This is a well-done motion because it addresses a lot of things. So one of the arguments Preston might raise, and that's the section we're in, is addressing arguments that Preston hasn't raised but might in the future. One of those arguments is that, look, the board, because trademark issues don't go to court. They go to a board, the Patent Trademark Board, the PTO. And the board of it's like 9 lawyers, which, God, can you imagine a bigger group of horror than that? They get together and they determine these things. So they will be hearing this. The board, what Ethan's lawyer is suggesting is that the board should go ahead and say, not only is this wrong, but you should also just go ahead and decide that Ethan has a common law mark. And in establishing that common law mark, they should go ahead and void entirely Preston's claims. Because if they don't do it now and they say, no, Preston has a legitimate claim on this, but then a subsequent action says, no, Ethan actually already had the rights. Therefore, that would strip jurisdiction from this board if a subsequent board said that you had the rights. So what they're going to say is, rather than doing that in the future and then obviating what was done today, why don't we just do it now? And then there are legal arguments presented earlier that say the board has the power to do this. The board has the power to consider these things that aren't the main issue before it because it makes the system work and it makes it work smoothly. And that's why they have it.
There you go. Ethan has the power to raise this motion to dismiss right now, and the board has the power to decide it. We'll see what happens. I think it's going to be interesting in any event. The proceedings are suspended pending disposition of the motion. Any paper filed during the pendency of this motion, which is not germane thereto, will be given no consideration. So this is going to go on the motion to dismiss right now, and we'll see what happens. Preston will probably have his attorney file to challenge the claims. If he doesn't, then I don't know, he might lose. And I'll leave you with the close here. Now, Houtteman's motion puts the ball back in Poulter's court to respond and challenge, and then the decision goes to the Trademark Trial and Appeal Board to either grant a motion to dismiss, which would mean an early victory for Van Sciver, or to say that Poulter's applications constitute sufficient grounds for standing, in which case the trial will proceed apace on a new schedule, perhaps dragging on for months or even years. Meaning, for the time being, the fate of the Comicsgate trademark will hang in the balance. Stay tuned. That's the update. This is Robert Romano with Comicsgate.org. Hit that subscribe button, ring the bell for notifications, and have a good evening.